positively disturbed. I just saw that somebody is connecting from Montreal, which is my hometown. So this is a small world today, and I'm very happy to see all of you today attending this international conference on artificial intelligence. The topic of today's session is this topic is artificial intelligence and law, philosophy, technology, and theory. We have the great pleasure of having two speakers this morning, respectively, Mr. Thomas Gabriel Garcia Miko and also Ritwik Prakash Srivastava, who will discuss their paper that they submitted to the organization. So it's what I also see, and the reason I mentioned that I've seen somebody from my hometown, which is always a pleasure. Of course, it's also a deep pleasure to see many people from around the world connecting to this seminar, to this international conference. So it just proves that the topic is given and is important for the entire planet. So that's very not only of this session, obviously, but of this international conference. So I'm very honored to be with you today hosting this seminar. My name is Sébastien Lafrance or Sebastian Lafrance, whichever way you want to say it, it's fine. You may also call me Seb. I have no problem with that. So today we have about 45 to 50 minutes. So I'm really looking forward to move on to give the microphone to the speakers. It will be quite interesting. So as I said, we do have, first we'll give the microphone to Mr. Thomas Gabriel Garcia Miko, who basically wrote, I have a few questions, who wrote a paper titled Dr. Robot Went Crazy, Liability Issues Arising from a Medical Device's Hackability. And also we have a nice paper that I read, so I'll have questions as well for a paper titled Alexa Will See You in Court, Artificial Intelligence and Freedom of Speech and Expression. But both papers raise very important issues from different perspectives and angle. So I expect that this will be quite interesting to hear from them, and welcome everybody. So if just practically speaking, during the time the speakers do present, if you have a question, please feel free to type your question in the conversation box, in the chat box on the right side of the screen. I will monitor it during the presentation. I will make sure to look at every single question. We may not have the time to entertain and discuss all the questions asked, but I promise I will do my best to relay them to the speakers. So just please make sure to identify to whom the question is addressed. Since we have two speakers, it shouldn't be too difficult, but still make sure to do so I'm not asking the wrong question to a speaker to the wrong speaker. So let's move on to Mr. Thomas Gabriel Garcia Miko. Thank you very much for being with us today. I assume that just like me, there's the time difference. I hope the time difference is not too hard for you today. It should be mid-afternoon, I guess, in Spain. If you are in Spain right now, I'm not sure, but so welcome. It's a pleasure to have you with us today. I read your paper with great interest. The first question I would like you to answer, if I may ask, is you wrote in your paper that the mere fact that a medical device is hackable is worrisome and might be deemed as ethically unacceptable, but legally irrelevant. So I found this very interesting statement. It's only one sentence, but it says a lot. So much so I will repeat the sentence you wrote. The mere fact that a medical device is hackable is worrisome and might be deemed as ethically unacceptable, but legally irrelevant. Quite interesting. Can you tell us more, Mr. Garcia Mico? So why is it worrisome? Why is it ethically unacceptable? And why is it legally irrelevant? So the floor is yours, and thank you very much for being with us today.
Okay, thank you very much, Sebastian. It's a pleasure to be here. Yes, indeed, I'm in Barcelona right now. So yes, it's midday. It's 1 p.m. And thank you for such a nice presentation. Well, about the issue that you raised about the paper, I wanted to differentiate between the ethical point of view as I do with the legal point of view. I think from my point of view that a medical device is hackable is in general something to be worried about. More if we take into account the specific cases that I relate in the paper. I relate cases of implantable pacemakers that are hackable. So we are dealing with medical devices that are, in many cases, essential for the life of people. So the mere fact that there is the possibility of a third party, a hacker or a cracker, depending on the term you use, that can be able to, or that can access to the system of this medical device and make it malfunction, or to make it function in a way that it is not, or for the way it's not yes, it's not intended when it's designed, it puts the life of people in the edge, in great risk. So that's why I consider that generally it is worrisome. About the unacceptability from the point of view of the ethics, I think that I make this the statement because I think that we are dealing with, as I said, medical devices that are fundamental for the life of people. So ethically, it's unacceptable because we have people behind that wants to, with not good intentions, wants to be able to access to these devices to do something with them. Something that, from my point of view, is, of course, ethically completely unacceptable. That's why I use the term ethically unacceptable, not from the point of view of the producer or the coder who does, from my point of view, whatever he can to avoid that risk. But technology normally evolves in a way that maybe the person who initially designs a product like this cannot expect that will happen. And the fact that it's legally relevant is because if we analyze the case law that we have, which is not many, but we have some precedents in the United States that consider that since the moment that the device has not been hacked and that the concrete person who is denouncing, claiming for compensation, has not suffered a specific damage due to this specific hacked act, is not relevant. He will not get compensation. The mere fact that yes, this device is hackable, well, the court in the United States will say yes, it's worrisome, like it does in two cases, but it's not relevant from the constitutional standpoint of the case law of the United States Supreme Court. Nonetheless, in Europe, we may have different criteria, not in cases that are hackable because we don't have case law in this regard. We just have one case of the European Court of Justice about pacemakers that could malfunction, but not due to a hacking act. And in this case, the European Court of Justice said that the criteria under the Directive for Defective Products was enough to find that there was a defect. Other thing is that this person can claim compensation because if there's no harm, broadly understood, because in the case of Boston, which is this case I'm mentioning of the pacemakers, the court considered that the costs of replacing those pacemakers was a harm under the directive. But in the paper, I make the difference. Okay, with products that are implantable, such as the pacemaker, we might have a harm if this device needs to be replaced by it. In other cases, with non-implantable devices, such as a surgical robot that is not implantable, there is no harm, Therefore, the product might be defective because it's hackable, but there's no right to compensation because there's no harm.
So the harm criterion would be basically kind of a Rubicon, if I may say it this way. So that's because you answered my second question. So maybe I will just ask you a bit more, specify my second question about the distinction between the European Union and the United States. So in the eyes of tort law, so that you discussed in your paper, so the criterion of harm could it be one of the main differences here, would you say? Or of course there are more, but in terms of distinction between the two?
Yes, in fact, in the United States, the issue has to do with the harm and also with a procedural obstacle about legal standing for an action, which is even a prior thing. And even the courts consider that in the United States, that if the product has not been not one product, no, the specific product that the plaintiff has or has implanted is not defective. The mere fact that your neighbor's pacemaker has the same is not a legally relevant issue. It's not a legally relevant defect. Here's where the United States court states in the European Union, provided that we have this protectionist way of seeing consumers, like the one who has this pacemaker, the issue is that the European Court of Justice has interpreted broadly the concept of defect, and it says, well, provided that in the European Union the criteria for assessing whether a product is defective or not has to do with the expectations, the safety expectations that the consumer is entitled to have. In this course, in this case of Boston Medicine Technique, the European Court of Justice said, well, one patient who has an implanted pacemaker has the legitimacy to think that his product or that her product will not be hacked. And the European Court of Justice, taking this broad interpretation of the concept of defect, even for hackable devices, allows us to consider that the product is defective. But the obstacle here is with the damage. The damage can be, of course, if the person dies because of the hacking act, there will be no doubt. We have a damage. But the European Court of Justice, even adopting this broad interpretation also of the concept of damage, including the cost of replacement the product, is saving the plaintiff's position for just one group of cases, which are implantable devices, such as pacemakers, defibrillators, etc. But not for non-implantable devices, such as a surgical robot or any other device that it has not to perform an action within and implanted in the patient's body, because in this case, there will be no harm because the surgical robot will not be replaced, and this will not suppose a cost for you. The case of replacing an implantable pacemaker requires a new operation, probably paying for this pacemaker, staying at the hospital, and the Court of Justice, in a different case but applicable to this specific group of cases, will consider that the plaintiff has the right to receive compensation. Even, I said, the device is hackable, so it has not been hacked, and there is no physical damage as such, like the death of the patient. There's just an economic harm.
Quite interesting. Actually, thank you very much for this short presentation. Actually, the paper is worth to be read. You just magnificently prove your master, your grasp of the topic. It was quite interesting. So just for wrapping this up, and of course we'll go back to you after the other speaker's presentation, and we'll open the discussion. But you mentioned one case of Boston, but I don't have the complete name. But just for the audience's benefit, would you have a few specific references to decisions of court that you would suggest the audience to have a look at?
Yes, I will refer to some cases of the United States. I have to check the exact name of the reference.
Well, of course.
The first case of the United States that it's worth reading and has to do with hackable devices, not medical devices, because it has to be with two cars. The first one is Keihen v. Toyota Motor Corporation, which was decided by the United States District Court for the Northern District of California, and was again confirmed by the Court of Appeals for the Ninth Circuit. So it's a federal case. This is the first one, Keihen v. Toyota. And the second one in the United States that it's applicable or that it's quite interesting is another case called Flynn v. FCA US LLC, which has also to do with a car. This case with a Chrysler car, but it has to do, again, with cars. And in both cases, the court says the harm is too speculative, therefore, there's no compensation. At the EU level, I recommend a case, and I remember that, and I remind that this case has not to do with hackable medical devices. It was a pacemaker that could malfunction and a cardiac defibrillator that could malfunction because of a technical issue. And this case is in German. Of course, you can find it in English, but the name is in German. It is called Boston Scientific Medicine Technique versus AOK Sachsen-Anhalt die Gesundheitskasse. And the second part is Betriebskrankenkasse. The references at the database of the European Union Court of Justice, of the European Court of Justice, is C-503/13 and C-504/13. They were solved in just one judgment.
They were merged. So thank you very much for the references. For those who don't speak German, I invite them to have a look, and of course, more than just for the references, but definitely to have a look at your paper that will, I assume, be published sometime soon. So it's thank you very much. Muchísimas gracias. Thank you very much, Mr. Tomás Gabriel García Mico. My apologies. Lo siento muchísimo. Let's move on, and we'll open the discussion later. But thank you very much, Mr. García Mico. That was quite interesting. So let's move on now to Mr. Ritwik Prakash Srivastava. If you can, I don't know if you can turn your camera on. There you go. Fantastic. Welcome. Another great paper that I had the occasion to read, and I invite people to have a look at, of course, once it will be published. Is that I had quite a great time reading your paper, I have to say, as well. So your paper, just to refresh so just to answer the question, the paper is not published yet. I'm sorry, the paper of Mr. Prakash Srivastava and the paper of Mr. García Mico are not published yet. They will be published at some point. So of course we'll keep you posted about this. Eventually, the organization will. So, Mr. Prakash Srivastava, welcome. Thank you very much for being with us today. It is a great pleasure to have you. It's nice to put a face on a name that I had the pleasure to basically read the article from. Right. So you wrote a paper, sir, titled "Alexa Will See You in Court: Artificial Intelligence and Freedom of Speech and Expression." This is a big topic as well, quite interesting, shall I say. In addition, I also have a few questions, if not several, to ask you about this paper. But if you can tell us first, generally speaking, about the challenges, and that's something you included in your text, the challenge that machines pose to the constitutional rights, or just the rights for those countries who don't have this protected in the Constitution. But what kind of challenges are posed to freedom of expression and speech when it comes to artificial intelligence, sir, if you can tell us?
Right. Thank you for that question. So that forms one of the basic parts of the fundamental parts of this questioning, of this questioning that I've undertaken by the means of this paper. So in very brief, the questions that I've sought to tackle are that artificial intelligence creating a digital profile of an individual. What it means is that the moment you step on into that ecosystem, that virtual ecosystem, the various artificial intelligences at play have already created a persona of you. For example, this person is a fan of New York Mets. This person is a fan of the CSK in the IPL. This person is a slightly left wing oriented person when it comes to politics. So there's a sort of digital profile or uh, that is created of yourself online. And that is where the artificial intelligence steps into the picture. Secondly, when the artificial intelligence starts acting as a moderator of the content that is presented for you, that you're allowed to see on the internet, the questions that arise are that of the artificial intelligence removing legal content that may be seen by the automated system as harmful. The content may be legal, but the same is being viewed as by the artificial intelligence as insightful, so it is removed. The problem here is that the process of this moderation is opaque for you. As a user on the internet, this process is entirely opaque, which means you don't realize when this happens. And this ties up with that question of digital profiling, that once this persona of you is created, the artificial intelligence can then moderate these content for you. So um, the second perspective you can say you can view this problem from is that me as a content creator, when I publish, let's say, my article, my videos online, the artificial intelligence that is at play, which is acting as a moderator on various platforms, be it the YouTube algorithm, be it Twitter's algorithm, it is limiting my content's reach to you. So the problem is twofold. In a very broad sense, the problem is firstly that I am not able to view anything else that does not come within the purview of my persona, and secondly, the content that already exists, the creator himself or herself is their reach is being limited, which means that this AI is acting like an intermediary between you and the world. It filters content for you, and for jurisdictions, for nations which do not have a policy in place as to how thick this plexi wall can be, problems can arise.
If I can jump in here, because you raised something very interesting, and that's all also raised in your paper, and I would like the audience to hear you about this, about the legal personhood of artificial intelligence, because you basically position the existence. Of course, there's a human being, there's a somebody else who wants to post something or basically track, but there's some opaque, that the word is really important, opaque world. So that also triggers, and that's why I would like to ask you this question here. But what can you tell us about the legal personhood and the debate about this? And what's your view? What are your views about the legal personhood of artificial intelligence in that context?
Right. So the concept of legal personhood is extremely central to constitutionalism. If I am to exercise my constitutional rights, they are to be conferred upon me, which means they are to be conferred upon my person. Now, me as a person, I hold certain characteristics. I have a sense of intention. I can I have a sense of belonging to a community. And the keyword here is that of an intention, that I am autonomous in my own sense, wherein I can exercise those rights. Now, placing the artificial intelligence or the concept of personhood on artificial intelligence in this context, with just this much information, that only the intention or this specific thing which is, let's say, specialized to humans, is needed for granting of a personhood, needs to be extended. The example that I've used in the paper is that of companies or NGOs or partnerships. They are granted what is called a legal fiction, using a legal fiction, a limited personhood, which differs from what the personhood of a natural person is, which means that we confer upon these entities, for example, Apple, for example, Samsung, for example, the CRY NGO. Upon these, we confer a limited concept of personhood so that these entities are able to exercise the rights which are conferred upon a natural person, but in a limited sense. I question. Do I sense a question?
There will be questions for both of the speakers, but I have a question here.
Yeah.
You just meant that I think it is important. So you said to a certain extent, so a partial kind of legal personhood. So you opened the door to to something I would like to keep commenting, because that's very key and very important. Yeah, please do. It's very interesting.
Right. So moving ahead from that concept of limited personhood that's granted upon these companies, there are certain rights that they can exercise, and then there are certain rights that they cannot. To put into perspective, Apple can hold property, but Apple cannot, which means that we have devised a system within the existing jurisprudence which says that there is something called a limited personhood which can be granted upon entities. And this is where I have tried to slot this opaque person, or this artificial intelligence, this person now that we see, whereby a concept of I have termed it so, the electronic personhood can be used to grant upon this AI limited rights, so that they are brought within the purview of the existing jurisprudence. And from here, I argue further as to how it's important to grant to them this personhood, because only then can you use this existing jurisprudence to begin with. Because the problem is that you have to start off somewhere. There has to be a starting point. You cannot come up with an entirely new concept and wait for a time when artificial intelligence is intelligent enough to be recognized as a separate or as a separate legal entity. You cannot wait for example, Sophia to come and debate with you on moral philosophical issues before you start regulating these ideals. And to start regulating these, right?
If I may just clarify, I know who that is. If I may say who, but if you can say who Sophia is for the audience who wouldn't know about Sophia.
Right. So Sophia is the world's first automated robot to be granted the citizenship of a nation. It's the nation of Saudi Arabia who has granted the status of a natural citizen to this robot. Now, that's just one instance, and I think it was more for diplomacy and soft power that the citizenship was granted, because we're not there yet wherein you can consider an artificial intelligence to be a naturalized person. And that's the point. That's the argument that I intend to put forth from my paper. That you don't need to regulate how the artificial intelligence interacts. You just need to regulate how the artificial intelligence interferes. And once we grasp that idea, that we have to start regulating the interferences, then the policy can develop. Then I argue is a good place for the policy to develop. Right.
Excellent. Thank you so much, sir. That was quite interesting. So, just because I was told that the third presenter is also among us, Paranjay Sharma, we'll move on to the presentation. But thank you very much. That was quite interesting. So to hear about artificial intelligence, legal personhood. So it went beyond freedom of expression, but still addressing it, but legal personhood, Sophia, and the limits and extent of, like, it was, I really enjoyed it. Thank you. Thanks again. It was, we'll get back to, there's a question for you, Sir Prakash Srivastava, that will ask, or if I may call you Ritwik, very respectfully.
Yeah, please, yeah.
We'll get back to the question after, but I would like to move on to the third presenter. Can I just confirm with the is Paranjay Sharma with us? Yes, he is. Fantastic.
Hello, sir.
Hello, please welcome with us. I apologize profusely if I thought first you wouldn't be with us at the very beginning. You probably were. I'm sorry about that.
No problem.
Thank you very much. So welcome, and I'm happy to have you among us this morning as well. And you wrote about the laws regulating facial recognition in India, which is a very important topic as well. So we've heard about medical devices from Mr. Garcia Miko. We've heard about freedom of expression from Mr. Prakash Srivastava, and now we will listen very, very carefully from you about facial recognition, of course, in the context of artificial intelligence in India. So it is expected to be, like, I'm sure it will be quite interesting. The first question I have for you, sir, is can you tell us very generally about the benefits, if any, not saying there's none, but if there are benefits of facial recognition based on artificial intelligence, and if you can tell us about this.
Right. So basically, the technology has immense benefits, ranging from its ability to help in finding missing children, identifying criminals, ensuring safety in public places, and preventing human trafficking in the prevalence of these these days, and general maintenance of law and order. However, this technology raises several privacy and security concerns as well, which needs to be addressed prior to implementation. Like, the pool of private data can expose the information to a data breach, thus violating the individual's fundamental right to privacy. Therefore, there is a need for ensuring the cyber security of such data to be protected in order to protect the rights of people.
And can you tell us about privacy and security concerns that would be raised in such a context?
Okay, so before I can further talk about on this issue, I'll just like to throw some light on the technical concepts and the underlying concerns for this. So we need to understand. Yeah, so we need to understand the core of this technology. So facial recognition technology is based on artificial intelligence, which leverages biometric data to identify a person based on their facial pattern. In simpler terms, facial recognition is a way of recognizing human face through technology. Now, in the recent months, the Indian government has also commenced employing this technology to enhance law enforcement enforcement capability. And as we know that facial recognition has become an area of an important interest to the Indian government, but there is no regulation in place to avoid the unlawful use of facial information. Thus, I guess it is a need of the hour to create an underlying framework for its usage, since this will undermine the democratic values and fundamental rights of the citizen. So now, before I further elaborate more on this thing, I'd like to state that before adopting this technology for public, it does raise some reasonable questions, as I said before, about privacy and rights of citizens, as you said. So there is no legal framework passed by the Parliament of India which authorizes the implementation and maintenance of such facial recognition technology and database. And the Indian Information Technology Act, which was passed as a first legalization on electronic format, has no reference to the facial recognition technology. Also, laws relating to data protection in terms of general data protection laws are, I'll say, very minimal and single civil or criminal provisions. So, under the Information Technology Act, it does not the current Information Technology Act does not encompass the facial recognition technology. So this is the problem that that we are currently facing, and the government, I suggested some recommendations, and the government needs to obviously step up and consider the data issues in a holistic manner before India moves forward in this direction.
So, if I understood you well, you said that basically the legal framework in India is minimal. Is that it?
Yeah.
And what would be one, you don't need to mention all of them. What would be one of the impacts of such a minimal legal framework for all of us, let's say?
For the general population, obviously, the government obviously needs to keep in mind, like, as I said, the private pool of data can expose information to a data breach. So the government needs to understand this and, come up with a policy or a legal framework to counter this issue. And moreover, I'll say that I've recommended some recommendations for implementation of this technology in India. So since this technology is relatively new, being introduced by law enforcement agencies around the world in order to identify persons of interest, the government needs to give the public more insight into how the technology functions, so that this will be a good step towards future in which technology inspires less fear and controversy. And if the government is implementing this automated technology, they need to establish adequate safeguards, redressal mechanisms, and create speedy dispute resolution forums to address any violations that may arise due to the use of this technology on a mass scale.
Wow, thank you. I didn't expect, of course, I should have, but I didn't expect such a complete answer to my last question. So thank you very much, sir. It was great. Thank you very much for your contribution to this seminar, this session. It was quite interesting to hear you about facial recognition and artificial intelligence, of course, in India. So that was quite instructive. And so if I may suggest at this point, because we have about 15 minutes left, perhaps 20, I would like us to move to the session of questions. I have a question here for Mr. Prakash Srivastava, but I invite everybody to type their questions in the chat box. I will be very, very cautious and careful to go through all of them. Please feel free to ask questions about the presentation about medical devices and artificial intelligence that was presented by Mr. Garcia Miko, or the presentation. We have a question for Mr. Prakash Srivastava about freedom of expression, and also the last presentation, not the least, the facial recognition in India and the legal, in the context, of course, of artificial intelligence, presentation by Mr. Sharma. Thank you very much to the three of you. That was great, very, very instructive on all these three topics. So let's move on to the question of that was asked for Mr. Prakash Srivastava, if I may. So there's, in the chat box, it says, basically, you are addressing this artificial intelligence advertisement, I suppose, filtering as one, it limits the reach of persona, and two, this artificial intelligence filters things out and doesn't allow to reach a new concept. So the question is, Mr. Prakash Srivastava, what could be the most optimistic and or, I suppose, productive solution for it? So the floor is yours.
Right. So thank you so much for that question, because that gives me a chance to actually narrow down this discussion on freedom of speech and expression. So the examples that I've pointed out and the references that I've taken in my paper include two major references. One is that of the Justice Puttaswamy versus Union of India, the Supreme Court of India's judgment of 2017. And I have relied upon ECTHR, the European Court of Human Rights, and the UNHRC's jurisprudence on how to deal with questions of freedom of speech and expression. So any interference with these constitutional rights essentially involves a three-pronged test to be fulfilled. The prongs are, first, of legality, which means that there has to be a law which governs that restriction. The second prong is that of necessity, that such a restriction should be necessitated. And the third prong is that of legitimacy, that such a restriction is in reference to a legitimate state interest. The restriction that we're talking about here is on the artificial intelligence acting as a moderator, as I see from the question. That how can you restrict or regulate or interfere with this AI moderator with interfering with your right? So the first prong of legality is what is lacking in major jurisdictions, be it that of the European Union, be that of the USA, and with specific reference to that of India. India does not have a law, a specific law, which deals with how to regulate these AI filters. So when that first prong of legality is addressed, as has been tried and is to a limited extent working in the jurisdictions I mentioned, those of European Union and USA, if such if such a dedicated legislation is brought in India, which seeks to address this question and takes into account variables. For example, what is the data set that the AI is being trained upon? What is the extent of scrutiny that the AI is allowed on a content? For example, you cannot expect an AI to have good understanding of what is satirical, of what is intended to be humorous. So, what kind of oversight or what degree of oversight is there on that particular AI system? What are the review or redressal mechanisms that are in place in case my content is deleted by an AI moderator? What recourse do I have? A good example of this is when YouTube does a copy strike on a video. The content creators usually do not have a recourse with the YouTube admin as to why that copy strike was there on my this specific content of mine. So if these specific criterions are addressed by a law, then within the existing jurisprudence of constitutionalism, as was my intention with the paper, to derive an understanding that the law as it exists can be tailored to include these instances. If such a law is come up with, which includes these variables and includes a multi-stakeholder perspective, whereby the state is not the only person who is creating these guidelines, because at the end of the day, the prongs of necessity and legitimacy need to be considered as well. So, lest it turns into a propagandic approach whereby only the kind of content that the government is okay with is being filtered as per law, these two three things need to be taken into account to come up with a policy which, when implemented, can act as a good regulator for addressing these concerns of limiting this interference of AI with your persona and AI filtering things out for you.
Excellent. Thank you very much for your detailed and complete answer to this question. I will now move on. There's a question for Mr. Paranjay Sharma, if he can turn his camera on.
Yes, sir. I think the network is slow. I'm trying.
It's fine.
Just a second. I'll just fix the issue.
Of course. Do you want me to ask you the question?
Am I visible now?
Oh, you are. Fantastic.
Okay, cool.
You're back with us.
Right.
So the question to you, sir, basically, what could be the privacy and security concerns? In general, can you briefly explain about how the private pools of data will be exploited? I just rephrased the question, not the way it was framed, but I basically relay a question that was asked in the chat box to you, sir.
So basically, the data accumulation and sharing can be good for solving crimes across jurisdictions or borders, but can also perpetuate racial and ethnic profiling, social stigma, and inaccuracies throughout all systems, and can follow for government tracking and surveillance on a mass level. And for instance, the Indian government approved the deployment of its AFRS, the automated facial recognition system, across the nation. Now, as we know, this technology collects data to create a map of someone's face. So basically, the thing that is of concern is that the mass use of facial recognition software, especially in public places, could erode personal privacy and be used to track people's movements. This is just a single perspective which I'm bringing out. And now there are multiple perspectives which are connected to this issue. So I guess the government really needs to find a customized approach on facial recognition technologies and protect the privacy and fundamental rights and liberties of its own citizens.
Excellent. Thank you very much, Mr. Sharma, for your interesting answer to this question. If there's another question for Mr. Prakash Srivastava, but before moving on to this, I see the clock is ticking somehow. So I would like to ask a question to Mr. Thomas Gabriel Garcia Miko, if he can turn his camera back on. Hello, sir. Welcome back. Well, you work with us, but I mean by way of camera. I would like to ask you a question regarding the medical devices. I'm curious to hear you from, and it's not necessarily discussed. It's more about perhaps furthering the issue. But do you fear, not you personally, obviously, but what are your views regarding the possible fear from people of criminals trying to hack these medical devices? Is that a risk that should be taken into account by the regulations or the laws? And if it is, how would it be contemplated legally speaking? I make the question very broad. You may answer it the way you see fit, sir. But I just was curious to hear you about this as well, if I may ask.
Okay, thank you. Well, in fact, I think that it is a real risk. So it is for the regulator to start providing with up-to-date regulations that may include this potential risk. And in fact, the International Standardization Organization, the ISO, have some technical guidelines about the quality management and post-marketing issues that may arise regarding the product, that they are already tackling the issue of the risks of hackability of products. So they say that products that are manufactured, that are into the public, that are into commerce, they shall be done with a system that avoids at most as possible the risk of the device being hacked. But aside from that, there is no specification about in the regulators per se. For instance, the Food and Drug Administration in the United States and the national authorities in the European Union, such as in Spain, the Spanish Agency on Medical Devices and Drugs, there are no clear guidelines on what happens with hackable medical devices. In the United States, the problem has to do with the fast-track process that some medical devices follow, that left aside this issue of checking for potential risks aside, and the scholarship has proved that they are indeed most dangerous than other products. In the European Union, we don't have this fast-track process, and those products that are implantable or that are fundamental for the life of the patient will be classified automatically as class 3 devices, and they will be submitted to stringent controls. But there's a silence.
So there are distinctions even about this, right? Between different jurisdictions and different approaches. And like you say in your paper, it is worrisome. So it's that's a key word that we'll keep in mind, of course, amongst the entire paper itself. But yes, thank you very much, sir, for your instructive and detailed answer. It was quite interesting to hear you more about this. So there's another question for Mr. Prakash Srivastava. If you can turn back on your camera, if I may ask. Thank you very much. So the question to you, sir, I just want to make sure I didn't skip another. Okay, here. So the question is, sometimes artificial intelligence-based applications act like superhumans. How the jurisprudence of legal personhood deal with this issue? So this is the question that was asked to you, sir.
Okay, so I first need some clarity on what's the meaning of superhuman here, as in sense of overreach?
I was wondering as well. Hopefully, I wish, and we all wish to be superhumans. I'm not sure if that can be clarified from the author of the question. Please feel free. Just give me a second, if I may.
Yes, I'm author of question.
Yes, please, sir. I'm sorry, you were in front of me, and I should have asked directly. Please feel free to jump in and ask the questions verbally.
Yeah, simply, so sometime I'm researching on pricing algorithm currently. If we grant the legal personhood to the developer or agency of the pricing algorithm, then sometimes they will create an output which human being cannot understand or even cannot explain how to reach this conclusion. And this capacity is a more than human thinks. And see, if we granting the legal personhood to the AI based any applications like this, which is a capacity, having a capacity that more than human beings and human intelligence. Okay. In such a situation, if we grant some rights to them, then simultaneously, correlatively, we should take the responsibility and duties from it. Okay. In such situation, how we can deal with this allocation of the duties concerning to the right, which is acting, which is not in confining with the or not in covering area of the human intelligence.
Right. So thank you for clarifying. So in my paper, the issue of this legal personhood is addressed fairly early. This is because the concept of personhood is utilized as a manner to bring the artificial intelligence within the purview of the existing constitutional jurisprudence, which means that once you have bought the concept of AI within the constitutional purview, it means that the existing principles can be applied. As of now, how such a situation would be dealt with, whereby an output of AI has to be basically the liability has to be traced as to who that output has to be attributed to, right? If I got the question correctly. So as of now, the jurisprudence on that is that of a functional approach, which says that whosoever has an operational command over the working of the AI shall be the one who is responsible. So the point of this legal personhood is only to the extent that the AI is brought within the purview of the constitutionalism itself, whereby you can then proceed with as AI becomes more sophisticated. Obviously, there will be more regulations that need to be developed. As of now, a functional approach is adopted. The references that I've used in my paper is the expert group report on liability of new technology 2018. This is the expert group report of the European Commission, which uses a functioning or a functional liability approach, whereby as of now, any output is simply traced to the person who has functional control or an operational control over that specific AI. I hope that answer was.
Yes, no, that was great. I'm sorry. Please, if you wanna add something, I didn't want to interrupt you, Mr. Prakash.
No. That answer. I hope I was able to address the concern.
Excellent. No, I think it was a good answer. Hopefully, I really think, not hopefully, I don't know why I say that, but I'm really confident that it did actually. So it was great answer, great detailed answer. We do have a panel coming up very soon, so I will have to wrap it all up with you guys. Let me just tell you, it was a great pleasure to hear from the three speakers, from Mr. Paranjay Sharma, from Mr. Ritwik Prakash Srivastava, from Mr. Thomas Gabriel Garcia Miko. It was different topics. So we see artificial intelligence is very rich in terms of legal issues, in terms of philosophical issues, in terms of ethical issues. So I had a great pleasure to host this session, to welcome all of you in this, and you may please join the next panel discussion in 10 minutes from now. So thank you very much for joining us today, and see you in the next panel or next panel discussion. And if not, see you very soon. So it was a pleasure to be with you, and stay safe, of course, stay well, and stay with us as we